I'm meeting today with Dan Bass, a mediator with an interesting background as well. But before we go any further with discussion, would you please give them your name and your contact information for those that would like to get in touch?
Sure, Eric. My name is Daniel Bass. My telephone number is 801-834-1107. My email is dan@utah-mediation.com.
So we talked a bit, as I will often do as we're setting up the camera or something like that, and tell people how you got involved in mediation.
Yeah. I was a trial lawyer for 25 years, and 25 years of going into courtrooms trying to explain to judges why your client should prevail and the other side should not prevail was kind of an unnerving experience when the judge just totally ignored the law and ruled the way they wanted to rule. And if you pointed that out to the judge, typically their response was, if you don't like it, file an appeal. That's not a practical solution for most people. Most people don't have the time or the money or the stomach, frankly, to be involved in the appellate process for that amount of time and that amount of money.
Tell people just briefly, what a lot of people, they've heard about appeals, and they think an appeal is just like, well, if I'm unhappy with the trial judge, I'll just ask for an appeal, and a month down the road, we'll have another hearing or something like that in front of a panel. What really goes on with an appeal?
Well, the reality of an appeal is the court has to find that the judge substantially variated from the standard of law. And most decisions of the trial court are upheld. Occasionally they are reversed and sent back to the trial court for another ruling. But it takes a lot of money and a lot of time, and like I said, most people's issues aren't worth that to them.
And
to
when
get
you
an
say
appeal.
a lot of money, what are we talking? $5,000?
Probably $10,000.
Yeah, 10 or 20
Yeah.
sometimes. And it's even worse in a divorce or family law case because the courts have a much broader discretion than they do in some other kinds of cases.
Exactly, and that's one of the reasons I thought mediation was such a great option for families who are going through a divorce. It gives them the latitude and the opening to create an agreement that both of them can live with, that both of them can feel is fair not only for them but their spouse, and is good for their children. If they go to court, they may get a ruling that neither one of them asked for and that both of them don't like.
Why would that happen? If the court can do whatever it wants, and sometimes does with disappointing effects, why would the court do something that neither parent wanted?
Sometimes it's a matter of, well, you've placed it in my hand. I don't think either one of you were all that right, and I think this is the best decision for your family. But the judge doesn't know the children, doesn't know the people. In a trial, the litigants are basically asked questions by their attorneys, cross-examined by the other attorney. They don't get to tell the judge their story, so to speak.
What's the purpose of trial then?
Well, the purpose of trial is for people who cannot make decisions on their own to be told what to do. And they have to do
If
that.
they don't get to tell their story, what are they doing when they're on the witness stand then?
They're answering questions that their attorney asks and that the opposing attorney asks on cross-examination.
For the purpose of doing what? To give the judge what?
Well, each side will try to bring out the positive points that they think will be appropriate for the judge to rule in their favor. And on cross-examination, you're trying to destroy those points and bring out other points so that the judge would look more favorably upon your position.
A lot of people going through a divorce, which in many cases is the first time they've ever been involved in the court system as well, will think that the court cares. Now, I know I wouldn't say I know personally, I know some judges that I feel really do consider the facts and try to keep in mind what's going on. I see others that, as you mentioned, far too often just think, I already know what I'm going to do, everybody's the same, it doesn't really matter. Do judges care about the people whose cases they hear?
I think basically very few judges do care.
Does that make them bad people?
It doesn't make them bad people. It just makes them, I'm doing my job as I see that it needs to be done and as it's legislated to be done. And if you don't like my decision, well, you should have reached one on your own, which is what they can do in mediation.
Right. And as we were getting ready, I was talking to Dan a little bit about, I don't like mandatory mediation, which Utah has, but it's not because I'm against mediation. It's because making people go to mediation oftentimes results in kind of a weird artificial scenario where nobody really wants to work together, but they're told, give it a try anyway. Sometimes people will come around, other times they won't. But tell us about what kind of person or people make for the best mediations?
In my opinion, the people who have the best chance of success at mediation are ones who come in and say, look, I want to do what I can to try and reach a fair agreement. I don't want to take advantage of my spouse. I want our agreement to be good for our kids. We're going to continue to co-parent, and unless we can do that effectively, it's going to affect our children as they grow up. So I think the best participants in mediation are ones who come in and say, what can we do to make this as easy as possible on everybody concerned?
What do they have to be willing to do to see that happen?
Well, they have to be willing to validate and see that the other side may have an opposing point of view that has some validity. Many times people will say or think, I'm right, you're wrong. And it's frequently not that. Everybody has a point of view. Everybody is entitled to their opinion. And sometimes when they're with a neutral party who is the mediator, he or she can point out to them, well, under the law, what you're saying may not be so. And here's what the statute says.
Because of your background as an attorney, do you like to see couples come to a mediation with their own attorneys? And when I say attorneys, let's make sure that I make one thing clear. You can hire somebody who says they have a law license and graduated from law school. I'm going to presume that we're talking about a skilled attorney. So if somebody brings an attorney to mediation, that clearly doesn't have any value in and of itself. But what I'm saying is, if the couple, both members of the couple bring a good attorney, doesn't have to be the most brilliant attorney in the world, but somebody who is competent, do you think that is better in the long run or generally, or do you prefer to see people come without attorneys and they kind of rely upon you to explain the law to them and how things can or do function?
In my opinion, I think it works best if they come to a mediation without attorneys. I personally don't make anybody sign anything if they want to take it to an attorney, because a mediation agreement is binding only if it's signed by both parties. So if they reach an agreement and their agreement is then reduced to writing, I don't want to put them in a position of making a decision that may have important effect on them, their money, their children, or whatever. And I say, take this home, or I will email you the mediation agreement. You look over it. If you have questions about it, feel free to call me. If you want to bring it to a lawyer, bring it to a lawyer.
Do people often think, well, by going to a mediator who has experience as a lawyer or is still admitted to the bar, has a license, then I can get a 2-for-1. I can have that mediator explain everything to me and tell me how the law operates, number one, and if it's a good deal. Why shouldn't people do that?
Well, a mediator can't give advice. And as a mediator, my job is to help both people equally, fairly, neutrally reach the best agreement they can reach.
Why can't they give advice? I mean, if you've got the ability to do it, I know I'm a big boy, I have to make my own decision, but I'd sure like you to tell me what you think I ought to do. What's wrong with that?
Well, it's against the rules of ethics for mediators. I mean, we're told by the rules that we cannot give advice. Now, I can explain things to people. I can say, if you go to court, the judge can do this or they can do that, but I can't tell you what a judge will do. If I was clairvoyant, I would tell you what a judge would do, and we'd just have an agreement and everything would be done right now.
And you'd make a ton of money.
That's right. Clairvoyancy has its rewards, but I'm not clairvoyant. So I try and explain to people clearly the pluses or the minuses of whatever they are contemplating. and say, do you need more information? What isn't clear, if anything isn't clear? How can I help you make a truly informed decision? Because a lot of times people will come to mediation and they won't know what the law is. I've had people come to mediation and say, I don't want to pay child support. And I have to explain that they very likely will pay child support, and we have child support guidelines, and the statutes say that all the judges should follow the guidelines unless there's some great reason for them not to. So the fact that you don't want to pay child support, what would you do if you were in court? Would you tell the judge, Judge, I just don't want to pay child support?
I just don't feel like I should.
Right.
Or
And what do you think the judge would say
Well, my
if you
ex,
said that?
my ex can take care of the kids without any contribution from me. It's like, okay, if the shoe were on the other foot, would you feel the same way? And things
Yeah.
like that.
Yeah, so I find that people in mediation, when they come to learn about how mediation works, to learn that they are the ones who make all of the decisions, I or any other mediator should not make decisions for them, but should be able to give them all of the information that they need to make the appropriate decisions.
Do you ever feel comfortable telling people that something that either is proposed by one party or perhaps even acceptable to both may not work very well? Because in your experience you've seen people try it before and it didn't work or it broke down, or you get a feel for the personalities and say, that's really nice, kind of like, there are utopian societies sound wonderful, but none of them have yet to survive. I mean, do you see where I'm going with that?
I do, and I think that I have a duty to question people on, okay, how do you think this is really going to work in real life? If somebody has been the dominant party the entire time of the marriage, what makes you think it's going to change if you're not married?
That's a good point.
So,
I've really never heard
to-
anybody explain it that way before, where you might have somebody who's subservient, whether it's the husband or the wife, and say,
Yeah.
just because now you're legally on equal footing doesn't necessarily mean that relationship will be that way.
That's correct. And, people have to look at reality. And I think my job as a mediator is to be objective, to be neutral, but to look at things with an objective eye. And if something isn't going to work, in my opinion, then I get to ask, how do you think this will work? Or what if this happens? What do you think will be the response?
Are you comfortable with saying, it's like, I got to tell you, I have my doubts as to whether this can work. I mean, could you say something like that, or would you feel that's inappropriate?
I think in certain circumstances, yes, you can say that, because I've had people come in and say, I don't want anything. I don't want child support. I don't want alimony. I don't want anything. I just want to be divorced. And I've asked, well, you don't have a job. You have 5 children. How are you going to feed them next week? So I think I have a duty to have somebody look at reality if they're not looking at reality.
That's good advice and a good perspective to have, because I think sometimes, let's talk a little bit about this just briefly. What are the biggest knocks that you would say are on mediators generally as to how they sell mediation to divorcing couples or unmarried couples with children? I mean, I see a lot of things. I have my own opinions, but this isn't about me. But I think you get the gist of what I'm asking. What disservice, if any, do you see mediators doing to people when they sell their services? Do they overpromise and underdeliver? And if so, how?
Sometimes. I tell people, look, I don't make any decisions for you. The only thing that I ask when you come into mediation is that you roll up your sleeves and you're really willing to work. Here are your issues. If you have children, you have children's issues. If you don't have children, you have other financial issues. Are you willing to work on those issues? And I get a lot of that because of a 25-year legal background. I litigated cases like that. I don't practice law anymore, but you can't divorce yourself from your education and your background. And I think it's a very strong background for people who come to mediation. I have seen mediation agreements done by non-lawyer mediators. where I might look at them and put on my legal hat and say, I don't even understand what they're trying to do here.
Or, I understand what they're trying to do, and it's illegal.
Yeah, or they aren't doing it properly, where it could be enforceable. Nobody wants to go through a mediation and then find out everything we've done doesn't matter. It's not enforceable.
What would be the best ways people can prepare for mediation? You talked about being willing to roll up your sleeves when you're there. What are the things that you wish people would do for their sake, not even for your benefit?
Well,
let's not worry about you, but what could people do to make it so that they don't waste time, they don't waste money, and they don't entrench themselves in positions that, even though we have to maintain a neutrality and objectivity, it's like, that's just a stupid idea. And what can they do? What should they be doing?
I think that's a great question. I think the first thing they need to do is take stock of what they have. Well, obviously, if you have children, you know their birthdays, you know their names and things like that. But do you know what credit cards you have? Do you know how much debt you owe on the credit cards? Do you have information about retirement plans? Are there savings accounts? If you own a house, who holds the mortgage? How much is left? What do you think your house is worth? So people should do a little bit of an assessment about what do we have? And then they can talk. I always encourage husbands and wives to talk with each other about, what do you think a fair way is to divide our stuff, or our property, or our assets, or our liabilities? So just know what you have and get an idea of it and put it together and exchange information before you come in.
You talked a little bit about a written agreement and that sort of a thing. Do you typically draw one up in the course of the mediation, or are there times when people will say that they want to sleep on it or something like that? What do you like to do at the end of a mediation session?
Well, I like people, number one, to have a comfort level with whatever they are agreeing to. I have seen mediation agreements where the mediator puts down what's known as a memorandum of understanding, gives it to the people, and says, okay, look it over and sign here. I don't like that to happen. I like people, and I know attorneys look at it differently, I like people who come in without attorneys. Take this written document home. Or you have a lot of things, I don't want to waste your time while you're sitting here and I type it up. Let me email it to you and see how it looks. Did I get everything right? Did I make a mistake? Did you guys talk about something after you left mediation? So from my perspective, I don't ever want somebody to call me a month later, a year later, and say, how come you made me sign that agreement?
You mentioned that people should have an idea of their debts and their assets and what they want to do for their children, depending upon if they're going to, they're going to live within a few blocks of each other or in different states and things like that. Can't they just agree that they'll divide debts equally? Can't they just say that they'll split their assets equally? Can't they just say they'll split retirement and pension funds equally, and that they will share the children equally? They'll have 50-50 custody.
Sure, they can say that, but then what if it doesn't work? What if one thinks this is equal and another one thinks it's not equal? So I think you've got to be a little bit more definitive, and I think that's my legal background speaking.
Oh, but it's
easy to say we'll split everything equally.
I just don't want to think about it, Dan. I just don't want to, all these debts and everything like that. Can't we just agree that it'll be 50-50? What do you say to people in those situations?
I say, let me put it down in writing, and you then take a look at it and see if I've captured what you want to do.
So there is some value added in that. You'll say, hey, I know that you could say kids 50-50, 60-40.
It doesn't mean anything,
but it
though.
doesn't mean anything. And yes, you have an agreement. It might even be an enforceable agreement. But what that agreement ultimately means is what you've really done is bought yourself a chance to go to court anyway.
Correct. And one of the big things that I see for my job, so to speak, is to try and keep people out of court. I don't want to create an agreement for them that a year from now, or 6 months from now, or 5 years from now, they have to go back to court because somebody doesn't believe what it says, or they both interpret it differently.
Yeah, or it's unclear or something like
Yeah,
that.
and when you say, we'll split everything 50-50, that's pretty unclear from a legal standpoint, as you know.
You like people to meet together, or, and some people may be familiar with this, but others aren't, or do you like to have the parties be in separate rooms where you meet with them privately, going back and forth?
Great question. My personal is I like to meet with people together, at least initially, to find out how they interact, how they talk with each other, how they may negotiate with each other, to find out if they can openly express opinions without being jumped on or cut off. And if one of the parties feels that they don't want to be in the same room with the other party, well, I can meet separately with them. I have a conference room, I have my office. I might have one party in each room and I go back and forth. But on the whole, I think most parties are able to work very well together. And that generally will speed the mediation up rather than
I was going
running
to say,
back
I'm glad
and
you
forth.
mentioned that, because you're right. If I may, in my opinion, there are times when meeting separately makes a lot of sense. There are some mediators that will never even try to meet in the same room, which I think is too hasty. But if you can meet in the same room together, you can talk, because otherwise you're not just simply doubling the amount of time, you're tripling the amount of time, because it has to be, well, all right, Dan, this is what I want my spouse to know, and these are my proposals, and here are my reasons. And then you have to go and tell that to the other person, and then listen to what that person has to say, and then come back and tell it to me. So you didn't just simply double the amount of time and effort, it's tripled. Because if I had been in the same room, I could have said it directly to my spouse, and then listened to her, or him as the case may be, as it was, as responses and objections or disputations came forward, and then it'd be in real time. You could then say, it's like, all right, I think I see something that maybe the two of you don't. Here's a possibility. I see both of you wanting something, but I think you're actually on the same page.
Well, exactly.
Yeah.
And that frequently happens. You'll see people that think their ideas are totally 180 degrees apart, when in actuality they aren't. They may be talking about the same thing, just in different language. So as an objective observer and as a neutral party, I can say, well, what I hear you saying is this, and what I hear you saying is that, and they aren't that different. What if we tweak this a little bit or tweak that a little bit? How would that work for both of you?
How long do you think a mediation session should last for the average couple? Now, I realize no two divorces are alike, but at the same time, it's very common for there to be a husband and wife with 2 or 3 children, a house, some debts, and some retirement assets, and some personal property. What do you think of all day, or half day, or 2 hours? Or what do you think is a
My
fair amount of
personal
time?
belief, and I've been doing this for over 20 years now, and I've mediated over 5,000 cases in that 20 years. My personal belief is that if you go all day, a lot of things get lost. I like to limit a mediation session to 2 hours, and I say, we're going to be here for 2 hours. 1 hour isn't enough. You're at the end of 1 hour, you're just getting to where you really need to be.
No matter how well prepared you might have been in
Correct.
advance.
But if at the end of 2 hours, you might be 95% through everything that you need to go through. Well, sure, if another 15 minutes or whatever will take care of it, we do that. But sometimes it's, well, I need to think about this or think about that, and set up another mediation session. I'd say probably 80% of the mediations that I do last about 2 hours.
And if you're 60% of the way through after 2 hours, what's your solution?
Well, to nail down what the differences are that remain, and say, okay, here are some things for you guys to think about. Here are some different options. Here was your idea, this was your idea. Let me throw in another idea or two, and why don't you discuss it or contemplate it?
Are you just
and
angling for another day of mediation?
No, not really, because I'm just as happy if they could get everything done right then and there.
Can you have them come back though? Are they free to do that if they said, well,
Absolutely.
we made a lot of progress, but we are kind of tired and we don't want to be confused or desperate, so don't.
And that, for people who require more than one session, that is generally the reason why. Sometimes there's so much information, their head's spinning. And certainly nobody wants to make a decision that is legally binding and important. When your head is spinning, you want to contemplate it, think about it, and come back. Well, you might come back in 3 or 4 days, you might come back the following week. But like I said, about 80% of the mediations are concluded in 1 2-hour session.
I think you can agree that you'd be in good hands if you were meeting with Dan. So I appreciate you taking the time to explain this process and some of the things that go into it, how to prepare, what your particular style is, and that sort of thing. And I've learned. I talk to a lot of mediators, but I've learned some valuable things as well. So before we go, for those that would like to contact you for their mediation, please give your name and contact information for them one more time.
Great. Thanks, Eric. Yes, my name is Daniel Bass. My phone number is 801-834-1107. My website is www.utah-mediation.com. And my email is dan@utah-mediation.
Thank you so much.
Eric, thank you very much. Appreciate it.